Hello, everyone, and welcome. Thank you so much for joining us today for our presentation with Sherry Curticle, CEO of Evinra, Inc., and founder of Victim's Voice. Today, Sherry is going to be presenting on the rights and wrongs of stalking and domestic violence documentation. Just a few housekeeping items to go over before we begin the presentation. We are trying out 5 closed captions today. So if you would like to enable those, please go to the More button on the menu bar and select Show Subtitle. A transcript will also be provided within a week of the presentation. We understand this is the first time we're doing it, so if it's not working, please share your feedback so that way we know and we can make amendments for next time. Mode and video is also disabled. If you have a question for the presenter, please enter it in the Q&A box. Chat can be used to communicate with other attendees and panelists and alert us of any issues with the webinar. Certificates, a recording of the webinar, additional resources including the presentation slides, as well as a survey will be emailed to attendees within the next week. And if you are a call-in listener, please email Ashley at domesticshelters.org to share where we can email these items. Just a quick intro to domesticshelters.org. I hope that everyone is familiar with the resource and using our tool to help share information about domestic violence. But if not, we are the fastest growing online resource for domestic violence information. We help a little over 2 million people each year find the answers that they need about domestic violence. We also offer a searchable database of over 2,800 domestic violence programs in the US and Canada. And if you yourself are a domestic violence service provider and aren't sure if your organization is listed, please contact me at my email address below. And then, of course, a reminder that US-based shelters can set up a free wish list, which allows donors from anywhere in the world to ship items directly to your shelter. And then don't forget about our Facebook professionals community. You can find more information about that on our Facebook page, domesticshelters.org. And finally, the Purple Ribbon Awards. We are getting near the deadline. The deadline for nominations is March 31st. So less than 3 weeks left to submit those nominations. We will be awarding up to $30,000 in grants to our top winners. And we're also very grateful for our partnership with Victim's Voice. The top winners will receive 10 Victim's Voice licenses, and you'll learn more about what that means as Sherry shares more about what Victim's Voice is and what it does. And all people who are nominated will also receive 2 licenses so they can kind of test out the functionality and help out their clients through offering those. And so, yeah, like the Purple Ribbon Awards, we're recognizing people across our organizations, people and other groups across over 30 categories. And like I said, the nominations are due at the end of this month. So go to purpleribbon.org to learn even more. All right. Now, and so with that, it is my great pleasure to introduce our speaker and presenter today, Sherry Curticle. Sherry is the Victim's Voice front lady whose superpowers include taking unpopular, complex problems and creating easy-to-use solutions that generate measurable results. She is a survivor of over 29 years of child abuse and domestic violence and has endured the criminal and family court system experiences. Sherry has spoken for professional organizations and has published several industry papers, magazine articles, and continuing education courses. Working in the tech industry, she was responsible for coordinating the first international keynote webcast between CeBIT in Germany and CES in the US, and has hosted and presented for countless webinars and live conferences. Throughout her career, attention to giving back has remained a high priority, acting as marketing and technical director for NJ Farm to School Network, event organizer for Fernbrook Farms, annual fun run, and gardener, growing and donating raised bed vegetables at her home for her local soup kitchen. Her focus is now on making a measurable difference in the lives of all victims and survivors so their abusers can be held accountable and they can begin to reclaim and rebuild their lives in safety on their own terms. Sherry, welcome, and thank you so much for being here today.
Thank you very much for having me. I really appreciate it. All right,
Absolutely.
so I am going to share my screen as soon as I'm able.
All right. Let's make sure that you're able to do that.
All right, here we go.
I just want to share a fantastic turnout today. We have 415 people already signed in, and I know that number only continues to grow as we progress. So thank you everyone for attending. This is a fantastic turnout and so much great information to share today. So with that, Sherry, please go ahead, and looking forward to hearing what you have to share.
Okay, before we get started, I don't see the poll question. So I'm going to ask you, I'm going to ask you to go ahead and pull up those poll questions. Great.
Right.
So before we get started, I just wanted to kind of get an idea of who's here. So if you don't mind, fill out kind of where you fall into the category of how you support domestic violence victims and or survivors. I'll give you a few minutes. And then I'll let you judge when the poll should end.
Yeah, it looks like we're actually allowing people to vote on both questions at the same time. So I don't know if you want to.
Oh, okay, that's fine.
Yeah.
So the other question, really pertains to what we're going to be talking about. And do you currently recommend that the people that you serve document what's going on? And if so, how are you recommending that they document? So that's the second poll question.
All right, we're at about 40%. Let's see if we can at least get to a little over 50. We'll get those answers in. We'll give another 10 seconds here. Okay, I'm gonna go ahead and end the poll, and that should share our results with everyone.
Okay, so large amount of people are victim advocates, which is great. This is going to be very valuable information for you, but it will also apply to others in the space as well. All right, and do we want to look at the other one?
Are you able to see that?
Yep.
Second one? Okay.
No, not yet. I'm not sure. There we go. We'll close that one out and we'll look at the results of the second one. I don't know how to do that. Okay. We're going to move on.
I'll share. I can see them on my screen, so I'll kind of give a verbal recap here. So it looks as though 37% use a paper-based journal or notebook. 16% are printing out communication and storing it. So more of a physical form there. 15% are taking pictures and sending them to someone they trust for safekeeping. 10% are telling them to record audio, video, then send it to a friend or to the cloud. 11% are their mobile phone or computer backing up to the cloud. 6% an app from the App Store, and 9% don't recommend documentation.
Okay, great. That gives me a good idea of where people are. All right, so for the purpose of this presentation, I'll be using the term victim to refer to those currently experiencing an abusive relationship or from someone with whom they were in a relationship and are still experiencing abusive behavior. All right, so there we go. Now, 8 out of 10 domestic violence reported cases are dismissed primarily due to a lack of evidence, but also because victims are too scared to testify. Attorneys and well-intended people tell victims to document everything, but not everything is admissible as evidence. In fact, most of what is collected and documented by victims does not meet the criteria as evidence and won't be allowed in court. So why does this matter? Well, these are individuals who feel a complete loss of control with nowhere to go and really no one to trust. They're going out on a limb and trusting you and the advice that you give to be true and accurate. They trust you have done your homework, a thorough due diligence by asking all the right questions, knowing and understanding the pitfalls of their legal ignorance, and understanding the capabilities of the technology to meet their needs for protection and legal justice. In addition, attorneys, prosecutors, and judges are counting on you to recommend technology that will hold up under the requirements of the law, scrutiny of the defense, and judicial review. So with a deluge of advice, apps, and resources, how do you take advantage of industry advancements to best guide someone experiencing harm without inadvertently or unknowingly harming them further by the very tools you've recommended? How do you wade through the onslaught of options to guide them to safely arm themselves with the information they need to get the appropriate protection and be able to seek legal justice if that's their path? This is why we're here today, giving you the questions and the why behind them to make sure you're properly and thoroughly vetting your options so you can make an informed decision for the safety of those most in need of your advice and direction, and provide answers that satisfy the needs of your organization and the legal process. So we're going to be covering 4 key areas. We will cover the following topics. So by the end of our hour together, you will have a clear understanding of the important role the right technology can play. And leave here with the resources to ensure you're asking the right questions, have educated yourself on the different options, and can make more informed decisions in the technology you're recommending. And shamefully, I hope you will consider victim's voice as a tool. So let's get started on the technology. There are really 3 primary types of technology that we're talking about here. You hear about using an app. That's what we call a native app or an application. Now, when you use a native app, that's something that you download from an app store, whether it's Apple's App Store, Google Play, or whatever, and you download an application on your device. That creates an icon, and then some days later, you are also emailed a receipt. Even if it's a free app, you're still going to get a receipt from the App Store. That receipt will include the name of the app and the developer. So this is why naming can be very important. Each application from a developer's perspective, from the technology perspective, means that they have to write code for an iOS or an Apple version and an Android version. And if it's on multiple types of devices, maybe like an iPhone, a tablet, a computer, a watch, any of those devices, there has to be additional programming to meet the constraints of that type of device. So you can see where that can be not only costly, but time consuming, and making sure that all your versionings, as we call it, across the board are consistent and meet the terms and conditions of the host developer company, such as Apple or Android or whatever. When you download an app, there's an icon picture and an icon name. Now, this is something to be considered very strongly because you are recommending this be downloaded to a device that oftentimes is being monitored. So having a lock or some kind of cross or something that might denote that that application is a security or documentation or safety app could potentially put the victim at risk. The name of the app is very important as well. Having a name that denotes something of what I mentioned on the icon can also potentially put a victim at risk. And the developer from whom it comes also, when they get that email receipt, if their emails are being intercepted, that's something to consider as well. When you download an app from an app store, you download an iPhone app to an iPhone, you download a tablet app to a tablet. That means that it's device specific. So if they can't access that device, they're not going to be able to access that app. So that's something else to consider with a native app. A web app is a website. It's responsive in nature, and most people now on the web have responsive, which means that as your screen size shrinks, so does your content. And on a computer where your content is side by side, will now relayer itself to be top and bottom. Some things to consider with a web app or a website app: being responsive and adapting. What kind of navigation does it do? Because if your developer is developing a web app and they haven't developed what we call a hamburger menu, which is those 3 lines you get in the corner oftentimes, then you're going to have a strung out navigation that the text gets very small, which means people are going to have to zoom in and out to be able to access that. And it's very difficult to click on the right thing. So that's something to consider, since most people do use mobile devices. That's also the same can be said for the copy that's on the page. If you have a lot of copy or text on a page, you're going to have to zoom in and out. And that can cause issues. It can cause angst. If you're dealing with someone with a lot of tears in their eyes, they're not going to be able to see it clearly. So these are all things that should be considered. Also with websites, the more you have on a website, the longer it takes to load. I don't know about you, but I get really frustrated when I'm sitting on a web page and I'm waiting that spinning wheel for the page to load. The last thing you want is for someone who needs to document to be waiting for a page to load to be able to even access their application. And lastly, pop-ups. A lot of websites have pop-ups, whether it's a chat functionality or a warning or something of that nature. Oftentimes pop-ups are very difficult to get rid of on mobile devices. In some cases, they're almost impossible. And so that's going to cause a lot of issues for the victim as well, trying to get to what they need to document. Now, a PWA, or a progressive web app, it's kind of the best of both worlds. So it functions as a web app. In other words, it is web-based, but it has special programming in it so that it knows what device is accessing it, and it resizes and reformats itself automatically to look and feel and act just like a native app. A PWA can be accessed from any device, so it's device agnostic. Whether you're on a phone or a tablet or a computer or whatever, it doesn't matter, because you can access the same application from any device. And you don't have to have a smart device to be able to access it, which is really important. So ownership is something that really the question should be asked. Who owns the application itself? Now, you may have developers that say, well, I own the app, but what's the platform that it's built on? If it's a form-based application, are they using on the back end something like FormStack or Typeform, Google Forms, any of those form-based things? Because if they are, then the data is not owned by the developer, it's owned by that third party, which means that that third party also has access to the data. So that's something to be considered. Who controls the information? Who manages it? And this is really about who can see the information, right? Who's managing, who's rolling out this application? So you may hire a developer to build it, but then you as the organization may be the manager of the organization. And how is it distributed? So is access guaranteed? Can anyone access it? Or are there criteria for a specific group? Meaning, if you're a university or a healthcare facility or something of that nature, where you have to be a member of some group in order to have access to it, then does that access go away for the user once they are no longer a member of that group? So that's something to be considered as well. So getting into the app. This is really important when we're talking about security, because one of the two things that our company always, an assumption that we always run under, is that the abuser will always try to gain access to the application. So you need to ask the question, the developers of the app will need to decide on the user's level of security, and they all have trade-offs. So SSO, single sign-on, is where you would use another application in order to access a different application. Sounds a little confusing, but think of it this way. There are applications where, would you like to sign on using your Google sign-on or using Facebook or Twitter? That is called a single sign-on. You're using that other application, Facebook, Twitter, whatever, to authenticate that you are that person, and then it lets you into the app. Now, the problem with that is if the abuser also has access to any of those apps, they automatically now have access to the documentation tool. Passwords. So passwords are, pretty standard, but that's the problem. They're pretty standard. Everybody uses the same password for multiple applications, and you have to memorize it. If you're using a lot of them, then you have to memorize what that is. And because they're usually case sensitive, and most developers will make them complex, meaning you have to use numbers and symbols, and they have to be certain characters long, and all of those complexities, it makes the incidence of a wrongful sign-on more prevalent. I like to say with passwords are like underwear. You should change them often and never share. But unfortunately, people don't do that. The other one is PIN codes. And PIN codes are great. They're easy. They're usually 4 or 6 digits long, but they're easy, which means that you could potentially guess it. And usually people share PIN codes, even more so than passwords. So, and it's easier to watch someone with a PIN code, and if you're looking over their shoulder, and then be able to access that. There's a thing called multi-factor or two-factor authentication, also known as 2FA. That means that you would sign on, and then you would receive a text message or an email that you would have to then put a code back in. Again, if the abuser has intercepted the email address or text messages, then they're going to have that. They're going to know that the user is documenting, and that's going to put them at potential risk. Biometrics are really great, except they're device specific, right? You can't use a thumbprint on your computer. If you're using something that is device agnostic and you're using a public computer, you can't use biometrics. So biometrics is really high security, but it also limits you to device specific. And then there's other ways to do, there's like personal questions. Banks use these a lot of times. You have to answer a question, or things like safe words and things of that nature. So there's other things that you can do. Now, viewing is getting into the application. One of the other things is if they can access the information once it's in, if it's a view only. If it's view only, you're potentially scaring the victim into not documenting in the future. If they can view the entries that they've put in there, when the love bombing starts and the nature of kind of falling back into that role with the relationship with the abuser, oftentimes they want to wipe out all the information that they've documented because they don't want it to be seen. Things are good. They don't want to rock the boat. So allowing people to view that can potentially scare them into not documenting more in the future. The other thing that can potentially do is corrupt credibility going forward. I know for myself that oftentimes a lot of my memories are based on pictures that I've seen in the past, not on the memory itself. So if you're showing someone something that is a picture, meaning that you let them see what they've documented in the past, that could potentially corrupt what they're going to put or alter what they're going to put in the future. If you allow people to be able to edit their data, now you lose chain of ownership. And that's a kind of a legal term, chain of custody, meaning that you can't prove that the information that they put in hasn't been altered in any way. And they can change the story if there's intimidation or regret sets in. So allowing people to edit is generally not a good practice. So we talked about getting into the app. Now let's talk about getting out of the app. How does the information get from the victim to the authorities? So federal regulation requires explicit consent from the victim for a specific purpose that any information be released. Therefore, it should be up to the user to determine if, when, and to whom the information is shared, unless it is specifically denoted as a reporting app where they know and they agree that any information that they put in is automatically going to generate a report that will be forwarded to an authority. That is a specific purpose, but if it's a documentation tool, then you would need to consider allowing them to determine when that information is forwarded. How it is shared is equally as important. There's email, not really secure, can easily be intercepted, whether in transit or once delivered. So most people think of, the email has been intercepted and somebody grabs that email. But there's other ways that that email can be intercepted as well after delivery. Somebody has the email on their desktop and somebody else comes by and sees it. Or somebody prints it, sends it to the printer. Now that's part of the print memory, and anyone walking by the printer would have access to that. Things to think about. Another way to access the information is a link to download. It's common with storage such as Google Drive and Dropbox, but usually anyone with a link can access it, and it makes it less secure from a people perspective. And then there's direct download. Forcing the recipient to create an account and log in to download a file is more secure. Add the additional security by adding a password to the document to open, print, or otherwise interact with it. Will secure it even further. This also means that direct consent would have to be granted in order for the recipient to be able to access it. When a victim is no longer to speak for themselves, how will you access all that evidence? So the tool should have a process in place so that the victim can name a responsible party intended to forward the records on their behalf when they are medically unable to do so. So as in real estate, so is in apps, location, location, location. Data storage. So there's terms that we use in technology called data in transit and data at rest. Data in transit or data in motion is data actively moving from one location to another, such as across the internet or through a private network like email. Data protection at rest aims to secure inactive data stored on any device or network, meaning that when the email is coming from me to you, that's in motion. At rest means it's sitting in your email inbox. Okay, so that's the difference. Storage, how is the information stored? Cloud storage, there are a few different types of cloud storage. We talk about things being in the cloud, but there's public shared clouds, which means that there are, think of this, I'm going to use the analogy of housing, okay? So public or shared cloud storage is like an apartment building, okay? And the building itself is the public or shared cloud storage. Your apartment, you have a key, you can lock your apartment and keep people out of your apartment, and everything in your apartment is safe when it's locked up, right? The problem with that, though, is that it can potentially get confiscated by the feds if one of the other companies is sharing the server space. So let's say one of the other apartment dwellers in that apartment building is dealing drugs, and the feds come and shut the whole apartment building down, and they don't allow you in. Now you've lost access to your apartment and everything inside it. So keep that in mind when you're asking about how is the data stored. If they say it's in the cloud, ask specifically, is it a public shared cloud storage or is it a private cloud storage? Private cloud storage means it's your very own cloud. It's your house. You have a key to the front door. You take care of everything. The plus side is that no one can access that cloud. The downside is that you need to have someone or a team of someone's that can properly configure, maintain, and monitor the system. Because in the apartment building, the apartment owner or the building owner took care of all the maintenance, right? They mowed the grass, they did all the upkeep and all that. With a house, you have to mow your own lawn, you have to do all your own upkeep. That's the same with the difference between the cloud storages. So all the security, privacy settings, all that need to be taken care of on your own if you have a private cloud storage. A third-party cloud storage, this is like iCloud or Google. Now, they're easy to use, and a lot of apps will automatically store to the cloud. And that's what people, they're like, well, I'm storing it to my iCloud account. Well, that's great, except Apple never will certify to you that their systems are clean and have not been breached. So if you try to prove chain of custody, you're not going to be able to do it with an iCloud account or a Google account or any of those accounts. How long is the company going to store the information? Is it dependent on a subscription or a license? So when their subscription or license expires, that they no longer have access to the information? What if their subscription lapses? Are they able to renew the subscription and will all their information be back there? And what if it's a free app? Who's paying for it? And what happens if the funding runs out? Right? We all love free, but what happens on the free side when there is no more money to pay for the upkeep and the security and the storage and all that? All those are hard costs that have to be paid for. And if they're not paid for through a grant, how are they getting paid for? How is historical data stored? Can they access it years later? And does the company use backups and redundancy to ensure integrity and accessibility? And what's the difference? So you hear backup and redundancy. Backup is where a snapshot, a picture, if you will, is taken of the database and all the data inside it. And a copy is made and it's stored over here. So if anything should happen, you can restore that backup, and anything after that backup date would be lost, but at least you'd have a point where you could go back and make sure that you have all the information. Redundancy means that you're running the servers over multiple servers at the same time, so that if one server goes down, the other server comes up and takes its place. Think of it like a call center where you have a lot of different people answering the phone. If one person's on the phone, the next person picks up and you keep going. So that's the difference between backups and redundancy. So who's watching your data? System monitoring. This doesn't mean visibility of the information submitted, but looking at the technology system to ensure everything is working as it should. There is such a thing called system log files. It's a record of actions taken against the data, including things like date and time. Has a record been created? Has it been modified? Has it been deleted? And other important information that's used to troubleshoot an issue from a technical perspective. Also, user insights, being able to look at login attempts. Are there login failures? Are there a massive amount of login attempts that couldn't possibly be human, meaning that your system is getting hit and somebody's trying to access your system to try to breach your system? So that's what system monitoring is. System admin access. Who has access to troubleshoot your technical issues? Is it in-house or are you outsourcing it? So if you're an agency that's using or recommending an application, is this going to be your application or are you recommending a different application? And are you going to handle the technical issues? Is the other company going to be handling it? And this goes back to who owns the technology. If the developer is using another person's technology, like we talked about in those forms, then think about this. The technical issue will have to go from the user to you to the app company, and then the app company will have to submit a support ticket to the third party and wait for help. So you can see how this could be a long and arduous process for someone in a dangerous, abusive situation to have to wait for support. So who in their organization has access to the systems or user data? Customer support? Do they conduct regular trainings to ensure privacy and security protocols are being followed? These are questions that you need to ask the developer. And how is the user's information shared with authorities or those working in an official capacity? Are they reports generated automatically? Is the information being reported automatically? Is it being reported on demand? And is it user driven? This is back to what we talked about, how the information gets out. And then user support. Customer service is going to be really important. People are going to run into issues. They're not going to be able to figure something out. They, can't remember or need to change their email or, whatever. So customer service, who's going to handle the customer service? And what protocols are in place to ensure an abuser trying to access the victim's account cannot gain that access? So again, lost password, new email address, all those types of things. Also with user support, does the company, the developer, share data with advertisers or marketers? This is really important to look at. And if so, what level of data are they sharing? And again, who's handling the tech support for the user? And does this include divulging potentially sensitive data on a support call? If the support team has access to the identity of the user of the app, if someone in that organization, maybe unbeknownst to you, is an abuser or a personal friend or something of the victim that's using the app, is that potentially going to put them in a situation that's going to out them? So all of these are really important things to consider. Now let's talk a little bit about legal and evidence. The devil is certainly in the details. So I like to call this the fine print. When evaluating technology that will be used for and by victims and or survivors, you should ask the company if they are following HIPAA and VAWA privacy standards. Do the users have control over their information's release? Who else has access? What information is being captured? And who has access to what? This is information of the utmost sensitive nature and should be treated as such inside the system and out. More of the fine print is what's known as the Daubert Standard. And this is the kind of the gold star standard of what is considered admissible as evidence in a court of law. And you can see what kind of those points are. It's called Rule 702, testimony by experts. If scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise, if, 1, the testimony is based upon sufficient facts or data, 2, the testimony is the product of reliable principles and methods, and 3, the witness has applied the principles and methods reliably to the facts of the case. Going back to number 2, the testimony is the product of reliable principles and methods, puts the onus on the technology company, that's us, to be able to prove that the above has, is, and will continue to be true. So technologies like blockchain, while exciting and cutting edge, do not meet the criteria and might be subject to scrutiny and ultimate dismissal for this purpose. So don't get all starry-eyed over blockchain. As developers, there is a legal and moral responsibility to the user. Some of the legal responsibilities are terms and conditions, also known as terms of usage. These are the terms laid out to the user for using your application. It may include responsibilities assumed by the user, such as stating if you, as the user, upload video into your account, you take on all legal responsibilities for doing so and cannot hold the developer and/or company legally responsible. Before recommending any technology, make sure you read through the terms and conditions carefully. Bear in mind, though, that the company will need to protect themselves from a good amount of legal liability, but you want to be careful as to what the user must agree to that you are recommending. Privacy policy. This is where the company must tell how they use the user's information. This should also be read very carefully because it tells you who they share data with. Now, every company shares some data. For example, if you use email, you're sharing some data with the company who created the email application, the company hosting your account, and the internet service provider, also known as an ISP, that you use to get your internet. Long story short, data must be shared, but understanding the difference between sharing to accomplish a task and sharing to market or advertise are two different types of sharing. If you are bound to VAWA VOCA FIPSA rules, you need to be sure you are carefully vetting this process as to not jeopardize your own legality. And breach notifications. Every company and organization will get breached at some point. It is never a matter of if, but more when and to what extent. So, how does the app company notify users of a breach? What will that notification process potentially do? Will it put them in danger? Is there a process during the registration of a new account or in their account settings that gives the user the ability to decide how to receive these notifications? So now we're going to talk about some of the moral obligations. Notifications. Breach notifications are not the only ones to be considered. Discussing earlier the terms and conditions around audio and video files. You can put the terms and conditions in the T&C section, but will a traumatized victim in the moment of abuse stop to read the terms and conditions to see what the rules are? Will they even know their state laws? It is a moral obligation that if a developer allows or even suggests audio or video file uploads, that they create a warning at the time of upload attempt. This needs to be a strong warning so as not to be in the fine print and easily overlooked. And then decision outcomes. If the app being recommended is a reporting app, the user will use it to do just that. If it's more of a documentation tool, there should be some alert to let them know that the recipient of the report may be a mandatory reporter and is bound by legal obligation to report what they receive. If a victim is not prepared for what comes as a result, they should at least be notified and given the option to make an alternative decision. So to record or not to record, that is the question. Recording laws vary between state lines. So multiple states, most states are one-party consent states, meaning that as long as I'm part of the conversation, then I can record any conversation. If someone in the conversation is in an all-party consent state, and there are 10 states, I believe, currently in the US that are all-party consent states, that means that everyone that is part of that conversation or part of that circle of being captured has to give consent. That means, videos and audio. I don't know any abusers that are going to give consent. So I know personally our company is based in New Jersey. We're a one-party consent state. Pennsylvania, 10 minutes down the road, is an all-party consent state. And it is in fact a felony to record someone without that consent. So if you have a victim unknowingly recording audio or video and uploading that or storing that, and then they mention that, they can potentially face jail time and or fines. And that's the last thing you want your victim to have to go through again. We brushed upon this earlier, but we're going to dig into this again because this is really, really important. If they can access their own data, to what extent? So can they go back in that view only? And remember, we talked about potentially scaring the victim into not documenting in the future and potentially corrupting that credibility. So if your application that you're recommending allows them to be able to view their entries, just know that any subsequent entries may be based on what they previously put into the application. If they are able to edit the application, even if it denotes that it has been edited with a date and time stamp, you no longer have chain of custody because now that entry has been tampered with and the defense will rule it inadmissible as evidence, and now it's hearsay and no longer able to go into as evidence. So chain of custody, right? We've talked about this. What does that really mean? So chain of custody means the company holding the information can certify that the information from the time it goes in until the time it goes out has not been accessed, tampered with, edited, or altered at any time. It means the service provider, AKA developer, can show how the information came into the system, how it got to the system, and what happened to it when it was in the system until it was called out of the system. Authentication means the information that was entered is a true representation of what is shown and has not been altered to show anything different. It is really important to make sure any technology allowing for images or multimedia also documents who took the images. As someone may say, taking a picture would need to testify as a witness if they were present. If not, then that image is considered hearsay as to what transpired during the incident. It's also important to ensure the image or multimedia includes what we call metadata, or that technical information attached to the files showing when and where it was taken, from what device, using what application, and when the file was created and or modified. Yeah, don't hearsay. Well, hearsay is really important because a lot of what victims and survivors collect, police reports, snapshots of text images, things of that nature, are all considered hearsay in a court of law. So relevance is the information the victim is documenting relevant to the case. So a lot of times when you hand someone a diary or notebook or whatever, what they're going to document may or may not be relevant to evidentiary cases. So they may talk about how they're feeling and a lot of emotion-based stuff, and that is not necessarily relevant to the facts. Open-ended journaling or uploading document type information may not collect the relevant information. Authentication. It's really important to make sure any technology allowing for images or multimedia, again, also document the person taking it. They also need to document, they need to sign off on the fact that that image hasn't been altered in any way, shape, or form. And going back to hearsay, having the ability to upload old thoughts after the fact is hearsay. And allowing a victim to upload old information, such as old documents, gives them a false sense of accomplishment and hope, and does little to build evidence in a case. So make sure the technology is readily available from anywhere on any device to collect the evidence as close to the time and location of the incident as possible. Being able to document in the moment or right after the moment, as soon as they're safe, is considered a hearsay exception. And that's why it's really important that the application or tool that you're recommending is not necessarily device specific, because they may not have access to that device. And then lastly, substantive evidence. It's evidence offered to support a fact in issue as opposed to corroborating evidence. Often they're given a notebook or asked to use something collecting their free-flowing thoughts, but those can be emotion-driven and not collect the necessary evidence to be considered in a wrongdoing proceeding. So make sure the technology is poised to collect the right information. And collecting the right information goes right into entry types. It's important that the tool used offer a mix of options for the victim to document details, but those options don't put them in legal harm's way down the road. So let's explore some of these options and their potential pitfalls and their benefits. Open text. The upside is prompting with open text questions is vital to determining the state of mind at the time of the incident. The downside is it usually leads to the emotional side of the victim's perspective and leaves out crucial evidentiary details. Questions. It's imperative that you consider how the questions are presented. Have the questions been vetted by multiple professionals in the space to ensure you're collecting the right information? Are they leading questions? Are they worded in such a way that sound elitist or anyone can understand what you're asking? Are they using terms that everyone understands or industry jargon and acronyms? Are they long questions that require time to read? Are they complex questions? How do they have to answer the questions? Through text, pick list, multi-select? So scans and uploads, can they upload any file type or does it prompt for a specific file type? Does it allow for image uploads? Does it allow for audio or video uploads? Does it allow the user to take a photo from the application and upload it? Guides and prompts. If any uploads are allowed, does it ask for date of original, who authored or took the original, space for a description, acknowledgement that it is unaltered, and a true and accurate version? If audio or video is allowed, do you tell the user that it's not legal without consent of all parties in some states? Do you tell them that this is in the terms of usage or as a pop-up before they upload? Do you have a consent release for multimedia files? So if you are allowing for audio or video, is there a consent file that they can also upload to show that they have consent of everyone included? And then there's legal considerations. Is it hearsay or hearsay exception? Is the app designed to upload past documents such as police reports, medical reports, etc.? While these are great supporting documents, they themselves cannot speak as testimony. They do help identify the person that wrote the reports and allow you to identify them to call them to testify. Are the entries date and time stamped to show the victim is recalling the incident right after the moment? And corroboration of images of both person and the environment. So bruises and cuts, but also broken glass, fist-sized holes in the walls, the room torn apart. These are important images to be able to take. And geolocation. Geolocation helps establish the victim being where they said they are when it happened. But a note of caution, geolocation is only as good as the user allows. This means several factors can change a geolocation stamp in technology. Some of those are a term we call VPN. It stands for Virtual Private Network. And that means that it reroutes an internet address to show the location as anywhere in the world. So I can be here in New Jersey, but my device will say I'm in Canada, for example. So if they're using a VPN, it will throw your geolocation off. If the user denies device tracking when prompted by the app, then you're not going to have that geolocation. And if the user is using a mobile data plan and is pinging from a tower in a different location, this is particularly important, especially if you're allowing for any multimedia, which is considered surveillance. If they're pinging off of a tower that's in a state that's an all consent state, then you could run into issues. And was the audio or video legally obtained? So you have to be able to prove that. So we talked about metadata. Meta what? Metadata includes authentication, such as geolocation, date and timestamp, and a token validation. That's some of the information about the information that's going in there. Also, information about the device that's being used to access the application. The technology will know whether it's a computer, a desktop computer, or whether it's a tablet, or it's an iPhone or an Android, even down to what browser they're using from what type of device. And then on the images, it gives the device type that the image was used on and the exposure. It gives the code of the device. All kinds of information comes out of that. And all that is technical information that you can't access by looking at the picture. But in the case of digital forensics, they can pull that information out. So if there's ever any question about the evidence, a digital forensics expert can pull that metadata out to prove that that image is what they say that image is. So there's some extras. We call them here at Victim's Voice peripheral evidence. So domestic violence never happens in a vacuum. We all know that. There's always peripheral evidence, and many times is missed and goes unreported. Too often, pets are harmed or killed as a means of intimidation. According to the ALDF, each of the 50 states now has a felony animal cruelty law on the books. So if you're documenting things like animal abuse or intimidation through animals, that helps you with that animal cruelty. Victims don't realize that a lamp or a baseball bat can legally be considered a weapon when used in a domestic violence incident. Having kids in the home, even in another room, can be considered child endangerment. When a victim goes to the doctor for injuries but reports it as a slip and fall, it may never come up in an investigation if the victim omits it from their testimony. But if you're documenting that type of information in the application, that ties that to that record and allows you then to pull in that expert witness to testify to any injuries that may have occurred. Neighbors or friends who hear or see violence firsthand may be potential witnesses. If you're not asking the questions about it, you're going to miss that. When strangulation is involved, but there are no visible marks, just having documentation that he put his hands around my neck and I thought he was going to kill me can be extremely crucial to the safety of the victim and the strength of the charges. Stalking and intimidation are some of the hardest charges to prove. But if the victim has geolocated date and timestamp pictures of an abuser staking out at their home or workplace and other types of stalking, it can be much easier to prove and bring charges. And these are just a few examples of what a strong tool can do if it's collecting the right information. Oops, let's try that again. There we go. Because domestic violence does not discriminate, it is essential that the tool not lean into one group of people over another. Make sure the terms used and the labels created are not discriminatory in nature. Take into account the culture norms are very different, so the space created in the tool should be judgment-free. Language barriers play a huge role in those able to be reached. Make sure your tool is multilingual and the user can read the prompts, document their evidence, and generate reports in their language, as well as reach out to customer service should they have an issue. One of the most overlooked segments and the most vulnerable groups are those with disabilities. Recommending technology that cannot accommodate this segment of the population eliminates too many victims. According to a 2014 study by the Spectrum Institute, over 5 million adults with disabilities per year experience domestic abuse. Simple things can accommodate their needs, like large text and buttons, simple words and phrases, bright contrasting colors, and some simple coding to ensure screen readers can voice the text and images. So here's the shameless portion. Why us? So Victim's Voice is the only legally admissible documentation tool on the market today. We are a progressive web app. We are device agnostic, meaning there's nothing to download. We don't download anything to any local device, so anyone can use it from any device anywhere. They can even use a workplace computer or a public computer, say in a library, and they're not violating any computer usage rules or regulations because we don't store any information locally. We encrypt all the information of the user at account creation. So some of you on the call could be users of our application and we would never know who you are. It's important that you are able to access the evidence coming out of the application should the user become deceased or medically incapacitated. We have what's called a journal designee. That's a trusted individual that in the event of a death or medical incapacitation, that trusted individual has the rights and privileges to forward a copy of the report to a legal authority on behalf of the user without ever having to access the user's account. So that keeps the user's account integrity intact, but it also allows the victim's voice to be heard even when they can't speak for themselves. And records recipient. So FIPSA rules state that you have to, when releasing records from a domestic violence victim, you have to have a designated specific person that you're releasing them to, a reason why you're releasing them, a specific time frame, a reasonable time frame. So the way our records go out meets all that criteria. The user goes into their account and determines an individual, and that individual then has to log into their own light account that's been created on Victim's Voice. And from there, they can download a copy of the records. And once they download those records, they can't download them again. They would have to ask for permission to be assigned a records recipient again. Customer support is one of those areas that can be really tricky because you don't want to out the identity of the victim, but at the same time, you want to take care of their needs. So Victim's Voice does this through allowing them support through an in-mail system inside their application, which means they have to log in and use their secondary authentication to prove that they are them. And from there, then they can submit a support ticket. That support ticket comes into our team as just a user database ID. And then that question is answered and sent back into their in-mail within their own application. So at no time is their identity ever exposed. Our application is also granted in multi-languages, meaning any language that they need it in, it will be translated in. And then they can put the answers to their information, they can put their submissions in their own native language from there. So that's just a little bit about our application. Now, it's important to note that we do license direct to the victim. Not all of the users that we have on our program are around domestic violence. But we do also understand that victims of domestic violence are almost always victims of financial abuse. So $40 a year might as well be $4 million a year. That's why we created a partner program. We are a tool, we are not a resource. And it is important to us to make sure that we encourage victims to get in front of the resources that they need. And through our partner program, we partner with district attorneys, victim advocates, nonprofits, entities that are victim serving in order for them to be able to bulk purchase what equates to gift cards or activation codes, and then they can give those to the community that they serve. That eliminates not only the barrier to access, but the financial trail altogether. If a victim purchases their own license, there is a credit card receipt. It comes from our parent company, which does not say Victim's Voice on it. And if they access a code through a partner in the partner program, now we just see that a user has started an account. We have no idea, name, address, any of that information, because they've just used an access code to create their account and use their account. So all that information is encrypted. There's no trail. If you are applying for OVC grants, you can put our licenses in as part of your grant application. And we do meet those criteria to be grant approved technology. As a partner, you will also get a dashboard. So when you write grants, you have reports to submit to prove that what you're doing is making a measurable difference. Well, we understand that. So your dashboard will provide information about how many licenses have been granted to you, how many of those granted licenses have been activated, and how many of those active licenses are actively receiving data on a rolling 30-day period of time. This will give you a lot of insights without ever having to know the identity of the person that's using it. You will not know who's using it, just as we don't. Training. So as a partner, we create CLE programs, continuing legal education programs, all kinds of continuing education programs, training materials, marketing materials. All that is granted to you as a partner at no charge. Right now, our conferences are free, but in the future, we will be charging for some programming. And for that type of programming, you will get a considerable discount rate for those. Also, we have promotions where we will encourage people. Survivors love to give back, so we will encourage survivors to donate licenses, and they can then donate to a partner in our partner program. So you won't have to purchase those licenses. And we have many partners that have received those activation cards through our promotional programs. And better data, right? So we are generating a huge amount of data. And while we don't identify where that data comes from, we are able to give data like percentages of reports that include weapons, percentages of reports that include animal abuse, percentages of reports that include strangulation. So that kind of information, you're not getting through the reports that you have access to now, because most of those reports come through government agencies, which come through the court systems. And we all know that most cases never get reported. So if they're documenting it and never report, we still have eyeballs on kind of what's going on without having to identify any of the user's information. We are soon releasing, we're in beta testing now for our EAP solution. So if in your entity, you would like to offer this to your own employees, you can do so as an EAP solution. And the way that would work is you would have a web page where people could go in and they would say, I want to access a license. You would be charged for the license. It would authenticate against their work email, but they would set up their account under their personal email address, which of course would be encrypted upon account creation. So you would also have numbers and be able to see, allocated, activated, and usage numbers without knowing which employee has been using the app. This is particularly important because domestic violence in the workplace, which we've just done a series of webinars on, really impacts productivity and your bottom line. And if you can foresee that you have a lot of activity going on from employees without having to know which employee, you can plan for this and you can take advantage of our training materials, and you can offer more EAP solutions such as mental health, maybe legal help, things of that nature. So it gives you a little insight into what's coming in your own company. So this is our team. We are a small team, but we are a mighty team. And we have a whole host of very powerful advisory board. We are very proud of our new advisory board, and we will be making this a public announcement very soon. So you're actually the first ones to see who's on our advisory board. So the proof is in our pudding. We have been live for over a year and a half now, and we have users actively recording data in all 50 states. We have organizational clients, and this number is actually low. This slide was made several months ago. And we have confirmed cases, meaning because we don't know who our users are, we don't know when someone uses it in a court case. We do know the 2 court cases that are identified here only because the attorneys and the survivors both reached out to us to thank us and let us know that the reports were admitted in the court as evidence and successfully used. In addition, we're building metrics tools to ensure we hear our clients' needs directly, can communicate the actual change we affect, and can contribute with data to those drafting legislation for effective policy change. I apologize for the dog in the background. Working from home. We've created a tool that helps you in your interview process of applications and technology tools to ensure you're asking all the right information. So all this stuff that we've talked about today, we have a tool that is basically a question interview process that you can take developers through. It emails you a score that you can save until such time that you need to make a final decision. So you can be interviewing each of those companies, and when you're done and you hit submit, it emails you the figures, it gives you a scorecard, and you can save all that. So when you need to take it to the board or whoever is in the approval process, they'll have all the information right there. We offer tools and resources. We have a resource section, but we also, part of our partnership with Domestic Shelters is that you can search using their tool embedded on our webpage for their shelters. If you have additional resources, such as what you see listed here, we invite you to add your resource. There's no charge. We want to make sure that the right information is getting to the right people and that those who need it can access it. We also understand that, oh, I'm going backwards again. Let's see. There we go. We also understand through our communication directly with victims and survivors through social media that there are certain hot buttons, if you will, that they really need to know that information, like, can I record in my state? Are pets allowed in a protective order? What states have address confidentiality programs? And so it's information like that that we put in our policy page. We also identify the district attorneys in the states, and we're rolling out these maps through all the states now. And we identify who our Victims Voice partner members are. We also identify district attorneys and partner members in our Find a Resource that we had in the earlier screen. I mentioned the Lunch and Learn program. We do on demand. These are free, so make sure that you go to our calendar and sign up for our webinars. If you have events that you are hosting, we also have a button where you can submit your own events, and we want to help get the message out. So if you put the information on our calendar, it gives you a calendar page. We link it direct back to your page so they get all the information there, and we also promote it through our own social channels. And lastly, please follow us on social media. We don't have an email list for users because we don't know who they are. So we do most of our educational content and our outreach through our social media platforms. Across the board, regardless of the platform, our username is Victims Voice App. And so that's it. I will open it up to questions. I know that was quite a bit of information.
Yes, thank you so much, Sher. I know a lot to consider when people are, collecting evidence, but I really hope what people are taking away today is that, something new that we hadn't thought of before that would have maybe tripped up a client in court later on. And obviously, we're big fans of Victims Voice. We know the hard work you put into kind of vetting all the different questions and leaning on different experts to make sure that the evidence that is collected is really admissible in court. But we hope that people kind of take away from this is Other things to consider. I know you had mentioned that great tool that helps people to even compare technologies they might be looking at. So we'll make sure that that link is obviously was in the slides that we'll share, but we'll make sure that that link is included in the resources so people can check that out. But we did have lots of questions, so if it's okay with you, I'll dive right in. The first question, and kind of something that I think would be neat if it doesn't exist, is there a kind of a one-pager document that people can kind of lean on? I know a lot of people will have to, as you mentioned, go to boards, go to people that are kind of higher up making the decisions. Is there something that you could share that has kind of all these different things to consider in one place? Or what would you recommend people do to kind of, inform others about what you've shared today?
So the short answer is, well, this video will be made available. So there's a one stop right there.
Love it.
We also have a 3-minute, 37-second video that talks about our application and how it works. And that's available. If you go to our website, victimsvoice.app, you'll see in the top navigation, it says the app. And if you scroll down underneath the screen that you saw that has kind of all of our features and functionalities, there's a link under the button where a link to that video. So you can watch that video.
Awesome.
It's on YouTube.
Perfect.
But that also kind of has all the information. If it's partner program information that you're looking for, how do you become involved as a partner and get this out to the victims that need it? We also have a link on our navigation that says partner program. So you can go there, and that's all the information about how our partner program works, what are the requirements, and there's an application button to go ahead and apply for it right away. Yeah.
Fantastic. Great. Well, I'm making notes here. I'll make sure that's in kind of a summary resources that everyone can easily get to. The next question is back to that one party, two-party, all-party consent. That was something that when we first had our initial conversation, I was like, whoa, everyone needs to know this, because it's, like you said, everyone says, just record it. It's the name of the webinar, just record it. And there's so much more that people need to consider. So someone had an interesting scenario where I was curious too. If the victim resides in a one-party consent state, but the perp is in an all-party consent state, is the victim violating the law by recording? Are you able to answer that question?
I am not an attorney.
Yeah, right. And as
there
I was saying that, I was like,
there are so many nuances for every state as to those laws. So I would say, reach out to any attorney. They should be able to answer that question for you. And I would reach out to an attorney in your state and an attorney in that state, especially the one in the all-party consent state. I know that when we were having conversations with Apple, myself and my CTO, we're not available in any app stores. But when we were having early conversations years ago with Apple, and they were saying some pretty off-the-wall stuff, we couldn't record the conversation because even though we're both in New Jersey, they're in California, and we would have to have their consent. So I would always say to people, err on the side of caution. Now, with that said, we teach you workarounds to get around that. So if you do have an audio or video file, and you want to know the workaround, I'm not going to tell you what that is now because this is public for everyone to know. But feel free to reach out to me. My email address, if you're comfortable emailing me, is right there. If you're more comfortable reaching out to me through social media, you can do that too. Just know that nothing on social is private, period. We actually did a blog post about that. So be cautious when communicating sensitive information on social.
Very good information. Thank you.
Yeah. Ask an attorney.
Yeah. Yes. And let's, other questions came in about, documenting Facebook posts and documenting text messages. And I did kind of respond back, and I'd love to get your kind of an expanded answer on this. Is, obviously text messages are kind of hard to document because, anyone can say that this phone number is Steve Smith. Anyone can change the name of who that person's saved as. Are there, obviously there are ways then through Victim's Voice app to save text messages and Facebook posts and things of that nature. How does that work?
So that's not going to be considered evidence. That's going to be considered hearsay. It will,
hearsay. Okay.
Yes. And the reason is that I just had this conversation with someone a couple of days ago. They said, well, we have a user that is taking pictures of the social media posts that are going up. And, we're saving all those. We're doing screenshots of text messages. But chain of custody, the defense is going to have a heyday with that. And you can't prove without a shadow of a doubt that the person on the other end sending those is the person that's actually sending those. Facebook gets hacked all the time. Apple, I don't know how many of you have Apple devices, but we all had major security updates. You know why? Because Apple got breached. So you can't prove beyond a shadow of a doubt. Now, if you have pictures in social media of somebody standing in front of your house and it's date and time stamped and there's a restraining order, that is admissible. If you have a picture of somebody in a public place, waving a gun around and they were a convicted domestic violence, and they're not supposed to have any weapons, again, and it's got a date and time stamp of when that picture was taken, and you can, prove that that picture was taken on a certain date, that's different. But just the text, no, unfortunately.
Helpful, very helpful. One question that came in specific to the Victim Voice app, is there the possibility to immediately record video or voice notes or anything, in the moment? Are you always going to ask those intake questions that kind of take a little bit of time, an immediate collection?
So the first question that we ask is an open-ended question. So if they need to, it's important for them to get their thoughts down very quickly. So that open-ended question, they can use their phones. If they're doing it on their phone, they can use the phone technology. There's always that microphone button. So you can voice text things in. And we made sure that was present in our application, because there may be somebody that's disabled and can't use their thumbs to type it in. They have to be able to just text it in. So yes.
Very good. And let's see. Well, this is a great question for Michael. Have members of your company ever been called to testify regarding the product to kind of bolster? I know you mentioned you've really only at this point been contacted to follow up by two different people. So it doesn't sound as though you've been called to testify, but is that something you've considered and are prepared for if you have to kind of give this presentation to say why all this information is good and legal?
So on our report that's generated, we have a certification on there that our records, our system has not been breached, and that if they wish to contact us further, then they may do so. So we certify it, and we have to be third-party audited. We are going through our GDPR compliance certification now, because we are also rolling out a white label for other countries to be able to roll our type of platform out in their own countries. So GDPR comes into play there. So yeah.
One of the first things people kind of started commenting on was, wow, this is a lot of negative things I can't do. Could you speak to just maybe, what do you think are the top things that people can do and should be doing as far as specific types? I think that might be helpful to just kind of recap even, what you've gone over as far as what people can do versus, this is not a good idea.
Yeah, so I think it's really important to know what you're up against, first of all. And in this country, you are innocent until proven guilty. So the abuser is the person who is until proven guilty. And the burden of proof ends up on us as the survivors to be able to prove that what happened did in fact happen. The defense is not going to make it easy. That's their job, to get their client, the abuser, out of the predicament that they're in, being charged with this crime. So I would just say that just understand what you can and cannot do. So even if it's using our tool for your own knowledge of what you can and can't do, even if you're not interviewing anyone, but you just go through and see what kind of information you can document. But also think of it through an attorney's eyes, because ultimately that's how it's going to be viewed in the court. And I'm just going to use a scenario here. He pushed me down the stairs and he choked me really bad and he pushed me down the stairs and I broke my arm. I can't believe he did that to me. Well, first of all, he didn't choke you, he strangled you. There's a difference. Choking means something's lodged down in your throat. Strangulation is where your airway or your blood flow is constricted. So there's a difference in terminology. And this is really important even from an investigative point. When you go to the police department, if you have a relatively unseasoned police officer, they might not, and they're not trauma informed, they might not document things themselves in a way that's best suited for your case. So you have to be your own best advocate. Understand what the terminology is. Understand that not just what happened in that moment with the strangulation, the falling down the stairs or being pushed down the stairs and the broken arm, but did you go to the doctor and tell the doctor that you slipped and fell and broke your arm because you're afraid that the arrest won't stick and you'll have to go home and it'll be even worse? So document that you had to go to the doctor. Document that you had to tell the doctor because you didn't feel safe, because that will show that your character, that you're not perjuring yourself. But also, maybe that the kids were asleep in the other room. Maybe they didn't hear it, maybe they did, but now that's child endangerment. Those are additional charges that can be used. Did he threaten to hit you with a belt or a lamp or something? Those are weapons charges. Did he kick the dog or tell you that he was gonna, and I'm using he, but it could be anyone, that he was going to make the dog disappear if you told anyone? That's potentially animal cruelty, that's intimidation, that's a whole lot of different things, but all you're thinking about is that his hands went around your neck, you were pushed down the staircase and you broke your arm, and that's it. So you can see how even the subtleties that start off where he wouldn't let me go see my friends, he made me stay home, he told me I didn't have to work anymore, that he'd take care of me, but now I don't have access to any of my money. He took my COVID stimulus check and I have no way to get out. All these add up to a lot of evidence. So even documenting the little things, the nuanced stuff that may not present as illegal activities, in whole will prove the state of mind and the escalation of everything that leads up to the illegal activity.
Fantastic. Thank you for that. And I think, just looking back, wanting to make sure that everyone's kind of clear on this idea of it seems as though technology is really the best way to collect this evidence, because it's, the way that you collect it through victim's voice, it's unable to be altered. It's, it checks all the boxes as far as holes that the defense may try to put into the case. But, is there a role that paper or, physical evidence can play? And is that something you would suggest people continue to do? Or, do you kind of guide people, try to take advantage of the, apps like Victim's Voice?
So my own journal from my own abusive relationships, my attorney told me the same thing: document everything. I wrote everything down. And then I took my journal in and she read through it and she's like, okay, thanks. And she handed it back to me. She couldn't bring it into the courtroom and the judge certainly wasn't going to read it. So I will say though, that even if you're not in a place where you need it for legal purposes, keeping a journal can be extremely therapeutic. And not just while you're going through it, but after the fact. I just found a journal that I had written years and years and years ago. And when I reread it, I didn't even realize it was my journal until I got about halfway through it, because I didn't even recognize the language that it was written in, because I'm such a different person now than I was back then. And it made me realize I liken it to watching grass grow. You know, while you're in it, the grass is growing, you don't see. And then you go back to it and you read this journal, and it's like somebody just went and mowed down a really overgrown lawn, and you're like, holy mackerel, you know? The other thing is that if you keep really detailed records and you do have to testify, the defense's job is to trip you up and really blow your credibility. So any mistake in any details, you can't remember the time or the place, or, you know, heck, what the weather was like, they're going to question your credibility. And so having something that you can rely on to go back to that shows all that documentation is helpful, not only as, you know, putting forth evidence, but it's also helpful for when you need that safety net in court to have to testify, because you are a witness. You're not the case if it goes to a criminal case. The state is the case.
Yeah, thank you. I know that I want to obviously thank you for your time and for this awesome information. We're so grateful to be partnering with you and to have you out there doing this amazing work. We are at our time. We're just a little bit over it. So I just want to conclude with a couple of reminders that we have recorded this presentation today, and we'll send that out to all attendees along with a certificate of attendance, any resources, recap of the slides, and of course a survey that we encourage everyone to participate in and share the feedback, and that lets us know how we did today, and share any thoughts on other topics that we can cover in the future. So with that, Sherry, thank you so much for your time today and this information. So grateful to have you, and thank you to everyone who attended today. We'll be in touch via email with more upcoming webinars as we schedule them. Have a great day, everyone. Bye-bye. Thank you.